FBI Director James Comey says there is no absolute privacy in America. He made that statement on Wednesday at a cybersecurity conference at Boston College. Take a listen to this.
There is no such thing as absolute privacy in America. There is no place in America outside of judicial reach. Even our memories are not absolutely private in America. Even our communications with our spouses, with our clergy members, with our attorneys are not absolutely private in America.
With many questioning what this means for the average citizen, some believe that the Fourth Amendment rights are under threat more than ever. Joining me now is Raymond Dall'Osto. He's a partner at Gimbel, Riley, Guerin & Brown. Raymond, thank you for joining us.
Thank you, sir.
Now, Raymond, tell me, we've heard what Comey said. He says that there is no longer absolute privacy in the U.S. What are the implications of this?
Well, I think that Director Comey's first statement is a broad, almost philosophical observation that there is no absolute privacy in the United States, and for that matter, anywhere else in the world. But today, because of the type of technological means by which smartphones, whether you have your Android or iPhone or a smart TV, any other type of computer device, those are unable to be tapped into, and people can be under surveillance when they have no idea that they are. So I think the idea of absolute privacy, unless you are perhaps on a backcountry canoe trip somewhere up in Canada, is probably the case here. It's the case in Russia, China, Europe, whatever.
Most people think, when I'm using my phone, I'm sure you as well, your phone, your home, your conversations that you're having, you're not really thinking about people tapping in. You believe that you're protected, at least to a reasonable expectation that you have some sort of privacy. But can reasonable expectation be interpreted in a drastically different way by, let's say, the CIA?
It can be by the CIA or any other law enforcement group, whether it's in the United States or elsewhere. I've been practicing criminal defense for 40 years now, and have also done civil rights work when I headed the ACLU in Wisconsin some years ago. And people think you have the same right to what we used to call a landline at home. That is, the government would have to get a search warrant before there could be a tap, before there could be surveillance. Unfortunately, there's been a line of cases, as well as congressional changes in the law in the last 20 years, which have said that your cell phone is not protected the same way that a landline is, and in fact is much more open to surveillance and to being listened into without the need for a warrant. We defense lawyers fight against that. We believe that, and we civil liberties lawyers believe that the Fourth Amendment protects the person no matter where they are. It doesn't just protect the house, doesn't just protect the landline. And that is the struggle that continues to go back and forth in our system as law enforcement wants to try to listen in and tap or obtain evidence. And again, I'm not saying for bad purposes. For the most part, it's for good purposes. But what does that do on the balance to our Fourth Amendment rights?
And that's exactly what we need to address. I mean, these are core American values. The Fourth Amendment, written hundreds of years ago, really, before this type of technology was even developed. So how can our basic constitutional protections survive with this technological landscape just changing all the time? I mean, as you just mentioned, laws have tweaked in certain directions so that things can be tapped as a landline as opposed to now our cell phones. Aren't these core values somehow, is there any way to maintain them?
Well, you might be, you have to have vigilance, and you have to go out as defense lawyers, as citizens, to make sure that if there are violations of your rights, that you stand up for your rights, or else you have none, whether that's in court or contacting your legislator or just being aware and taking security measures. But you mentioned about the idea of, our Constitution, some 200 plus years old, and our Bill of Rights, very, very important. And there was a line of judicial thinking, particularly during the 1950s and 60s in the Warren Supreme Court, with some of my heroes, Justice Douglas and Justice Brennan, who saw the Constitution and the Bill of Rights as having to evolve to fit the newer times and the newer technology. Unfortunately, you have some of what's called the originalists, the late Justice Scalia and now the appellate court Justice Gorsuch, who has been nominated by President Trump to replace him, want to have an original. In other words, what would the founding fathers have thought at that time? Well, first of all, and if they didn't have this technology, are we limited in our rights to just what was back then? In my view, no. But this is an argument we're going to be having both in the confirmation hearings, and we have it constantly in the courts, and it's something that we have to do. If we don't do it, we lose the rights.
Raymond, thank you so much for joining us. That was attorney Raymond Dall'Osto.